All right. Cue the music.
Oh, no. So the Gorsuch hearings are going on.
Yeah, that's a thing.
Dahlia Lithwick is extremely unimpressed with Judge Gorsuch.
Why?
He is an originalist.
Is that all?
Before we go to that, can we talk about how Judge Gorsuch did not make law review? And I think we are uniquely qualified to talk about this because I didn't make law review either.
I extremely didn't make law review.
Tom, you made law review. You were like editor-in-chief of the law review. So in that sense, you are more qualified than Judge Gorsuch, because that's what we care about. But other than that, should we really have a judge that didn't even make law review?
Crickets.
Wow, you guys don't even care. I'm the only one that cares about this.
So Jamelle Bouie actually, Jamelle Bouie has this theory that it would be appropriate to have a lay judge on the Supreme Court at all times, someone who's like a doctor or an accountant, but not a lawyer. And there actually was some like academic paper that tried to use some method to prove that it would be optimal to have lay judges, but then I didn't read it.
Yeah, I saw his tweet about that, but the problem is the vast majority of stuff that the Supreme Court does is not overly political. And so you have just a lot of work in terms of legal work that needs to be done. And I don't know how much a non-lawyer could contribute to that, right?
Well, Tom, I think they could, because as Judge Gorsuch and as Justice Roberts have reminded us, in different words perhaps, but it's just about calling balls and strikes. It's easy. You're an umpire.
Can I actually say something about this balls and strikes rhetoric?
Yes.
Rhetoric going back to the Roberts confirmation hearings, but then also sort of hanging in the air on the Gorsuch hearings.
Yes.
I think that a lot of the forms of judicial interpretation that are used by conservatives, and I'll go back and explain that point in more detail, but to get to the conclusion very quickly, a lot of the forms of judicial interpretation used by conservatives have this sort of this sort of basis in judicial positivism, that there is sort of what is
judicial positivism?
Well, AJ, I'm going to get there, but there's some sort of like correct answer that is objective and can be derived by empirical means. So you can, using empirical research, if you're an originalist, find the meaning of the statute at the time that the framers of the statute adopted the text, for example. But this sort of like is an attempt, this like balls and strikes rhetoric, that there's this objective answer, right? So you imagine in baseball that a ball passes over the plate or doesn't pass over the plate, and that has an objective reality, right? Like that actually happened. Like you could say that like baseball has a subjective reality, but the spatial relationship between the ball and the plate has an objective reality. I mean, unless you're like not a materialist. But the point I'm getting at is that the law and government and the social contract don't have objective reality. So the idea that they're that originalism or textualism or really legal positivism, any of these like conservative philosophies posits, is that, like, oh, I'm just your humble scrivener.
Which is a phrase Judge Gorsuch used. It was awesome.
My God. But it's not my fault that the framers at the time of the adoption of the Constitution think that whipping slaves is good, right? Like, oh, we have this social obligation amongst each other to behave with fidelity to the political views of people who whipped their slaves. And this has a positive reality, an objective reality outside of myself. And so there's this right answer or this wrong answer in the law, that this baseball passed or didn't pass over the plate. And, like, I really wish, you frozen trucker, that more could be done for you. And that's just, I mean, it's stupid. It's just stupid.
Before we delve too deep into that, I think you threw out several Neil Gorsuch references, if you wanted to explain.
These sort of forms of judicial interpretation are a real ideological struggle. So just to like define a bunch of terms very quickly, originalism is this philosophy that the controlling interpretation of a text is the understanding of the text at the time of adoption by the framers who adopted the text. And so you have things like the Eighth Amendment prohibits cruel and unusual punishment. And at the time of the adoption of the Eighth Amendment in the 18th century, the framers of the Constitution believed that corporal punishment and certain forms of execution and indeed the death penalty itself were perfectly fine and were neither cruel nor unusual. So to an originalist, there is virtually no form of punishment that would be cruel and unusual.
So, not to throw a wrinkle, but in that scenario, though, like with cruel and unusual punishment, isn't that the only type of constitutional law that's sort of removed from originalism, right? Like the words cruel and unusual are relative words, right? Like cruel in reference to what? Relative in reference to what? So isn't there this entire philosophy that cruel and unusual evolves with the times?
So there are different originalists. So there are fairly faint-hearted originalists. Faint-hearted originalism is a term that Scalia used to describe himself. But there are excuses that originalists give to depart from this original intent. Sometimes there's a basis for it in the text. Like in the Eighth Amendment, you could sort of convince it yourself that unusual means unusual in the time of the carrying out of the punishment, as opposed to unusual in the time of the adoption of the Eighth Amendment. But those dueling interpretations of the text are entirely subjective. To an originalist, there would have to be some way to know when the framers who adopted the Eighth Amendment had meant by the word unusual to refer indexically to the time in which the punishment is carried out, or inflexibly to unusual at the time of the adoption of the Eighth Amendment. There are people like there's a philosopher and a legal scholar. His name is Easterbrook, and his idea is that there are going to be texts where the original intent of the people who adopted the text cannot be discovered, and judges should declare the original meaning lost in the sands of time, and that the contemporary political community just has to decide for themselves how they want to move forward. And the political community is sort of the legislative and political process and not the judicial process. And so even these like faint-hearted originalists, these originalists that give themselves excuses, they say, oh, the original intent can't be determined or whatever. They still sort of remove judges from a role in determining what ought to be done in society. I mean, the entire project, beginning to end, is totally bunk.
So I think let's take a step back for a second. On originalism, I guess the way that I've always thought of originalism, and correct me where I'm wrong, is the kind of basic idea that the people that wrote the text, or the Constitution in this case, wrote these words, and those words had a specific meaning at that time, and that meaning is fixed. Is that right? Am I thinking of originalism the right way?
Yes.
The meaning of the words does not evolve. So
I think that's also partially textualism, right?
I've never understood the difference.
So textualism is a philosophy that emphasizes to a high degree fidelity to the text. And I know what you're thinking. Liberals also read the text. And the answer is yes. This is sort of another form of marketing where, just like how both the Federalists and Anti-Federalists were for a federal form of government, everybody has some level of fidelity to the text, but textualists use their fidelity to the text as a sort of political bludgeon, as a way of suggesting that other people don't, right? Like originalism is not just a fidelity to the words of the text, but as an interpretive scheme, it says that the meaning of the text is fixed in time at the time of adoption.
Here's a slightly related question. Scalia is known as both a textualist and an originalist, right?
Right.
How does a textualist and an originalist, who presumably is trying to divine the intent of the authors of the law, dismiss so easily legislative history?
I don't know. That's always felt like a contradiction to me. Well, actually, I do know, actually. No. I actually do know this. I do know the answer to this. Let me take a stab. It's all there in the text, Tom, and legislative history is sort of bunk, right? Because one legislator said A, another legislator said B. How are you going to know which of the many different opinions that the legislators had actually controls?
That's not quite the textualist objection to legislative history. I mean, a lot of the textualist objection to legislative history is that it has two forms. First, it should be unnecessary, right? You could imagine a situation where Congress gets together and they say, we need to make it a crime to steal ice cream from the ice cream store. And there are all of these floor speeches where they say stealing ice cream from the ice cream store is bad and we want there to be less stealing ice cream from the ice cream store. And there's a scrivener's error in the bill. And it says stealing ice cream from the ice cream store is not a crime. There was a not inserted by some drafter. And now you have a bill that says the exact opposite of the contents of the legislators' floor speeches. A textualist would say that the floor speeches are irrelevant, that the bill says that stealing ice cream from the ice cream store is not a crime. So a lot of the textualist objection to legislative history is that it is irrelevant. The second point is that the legislators are only part of the political community at the time of the adoption of the text, right? So a lot of the originalist analysis of what the original meaning of the text is how the text is implemented by the political community. And that has all sorts of problems because all sorts of bodies pass legislation and then immediately refuse to follow it. And so the implementation of the legislation is just as fraught as the legislative history of the legislation. But again, originalism is bunk. And so this sort of, of conflict, you just hand wave away.
So why is originalism bunk?
I think a couple reasons. First, I think that this sort of positivistic assertion that the law has an objective reality, that there is an objective answer extrinsic to the wisdom of the judges themselves, is an excuse for conservative judges to reach deeply unpopular conclusions, right? There's a case that's been talked about quite a bit during the Gorsuch confirmation hearings where Gorsuch ruled as a judge on the 10th Circuit. He filed a lone dissent where there was a trucker. That trucker was in freezing conditions and there was a equipment failure in his truck. I'm not going to get too deep into the details, but basically there was a statute that said that you can't fire someone for refusing to operate the equipment in unsafe conditions. And what the trucker did was unhitch the trailer but drive off in the truck itself. And Gorsuch says, well, he didn't refuse to operate it. Indeed, he did operate it by driving away. And so the statute doesn't protect this person who was indeed suffering from hypothermia.
Yeah, I think the background to that case or that story is that the trucker basically had two choices. Either he could just stay and do nothing, which is what was ordered by his superiors, but he would die because apparently the heater wasn't working and it was like below negative 15.
Everyone should watch Senator Franken summarize the facts because he does an amazing job. And I will go to the show notes. Heartlanded.com. I'm going to put
at AJ Smolin on Twitter.
My Twitter handle is at AJ Small. I'm going to put Senator Franken in the show notes. He does a really good job of summarizing the facts.
If you can't find the video, you need to tweet at AJ Smolin, and he's going to find it for you.
Tweet at AJ Small. I'll DM you the video.
Yeah. Tweet at AJ Smolin.
It's a hot video. You're going to love that video.
Okay. So Judge Gorsuch writes this opinion, and the text of the opinion itself is fairly unsympathetic, but in his testimony, Gorsuch says, I'm like deeply sympathetic towards this trucker. It's just that the statute says that he didn't refuse to operate. The statute says that you can't be punished for refusing to operate, but indeed he operated the equipment, and so he didn't refuse to operate the equipment, and there's no protection for him. The idea that the law has some objective reality, that there's a ball that passes or doesn't pass over the plate, that has this objective relationship to our political community, is like totally bogus, right? The law is the thing that people do. The law is the things that people get away with without the force of the state in any of its manifestations preventing you from doing it. And those manifestations can be the executive power restraining you through use of force, or it could be the judicial power entering an order and joining you from doing it. But the reality of the law is that the law is the things that people do.
AJ, I think you don't even need to I wouldn't even go that far as it relates to Gorsuch here, because it's not just that the law is what people do, but it's also the law has to have context that's in it. And the context comes from the facts, because the law cannot outline every factual situation that can possibly exist, right? So Congress can't write a law that says which is sort of what Gorsuch demands, I think, in his responses to Al Franken, which is, it's not my fault. Why don't you write a different law? And is Congress really supposed to write a law that says that the definition of operating equipment does or does not include if you would die if you didn't operate the equipment this way? You know what I mean? This comes back to my sort of original kind of objection here, which is that they're taking the context out of judging and they're taking the judging out of judging. It's not black and white. There's nothing black and white about most of the cases that come before a court. There's always some sort of nuance. And what are you hiring a judge to do? Is to take the law and take the nuance of the facts and create something that resembles justice.
Yeah, I mean, I think that's all true, but I think that is not forceful enough as a critique of originalism and textualism. I mean, maybe it's sufficient as a critique of Gorsuch, but if you wanted to get real deep into the philosophy, there's just no point in the whole thing.
Well, so let's stick with this trucker example, the one where Judge Gorsuch ruled that the trucker used his truck and under a statute that says you cannot be fired for failure to use your truck. I don't know the exact language. The statute doesn't cover protect the trucker, right? But I think an originalist would say, well, finding a result that is not in line with what the statute says, or maybe this is what a textualist would say, would create uncertainty, and uncertainty is bad.
But the problem is that judges are only particularly useful where a text is ambiguous, right? So we've spent a lot of time in the last couple episodes talking about what you do when a text is ambiguous. You've got the rule of lenity, which says that when a text is ambiguous, the judge should show deference to a criminal defendant. That ambiguous statutes can't cut against a criminal defendant. We've also talked about Chevron deference. So when the judge reviews an agency interpretation of a statute, the agency has particular expertise that is deserving of deference from the courts. We've talked about how criminal statutes can't be overbroad or vague in a way in a way that wouldn't cause people to understand what conduct is criminalized or not, right? There are judicial devices that are used to resolve ambiguity. Where a statute is unambiguous, a judge is not particularly useful, right? Where, a judge is useful in sort of the pomp and the majesty of the judicial office that causes people to follow the law, right? That an injunction is sort of more useful than a gun sometimes. But the judges, particularly Supreme Court justices, the Supreme Court takes on 80 cases a year. There are thousands and thousands and thousands of cases in the country that never make it to the Supreme Court because people sort of understand where the chips fall. So for considering that Judge Gorsuch wants a job where he's only supposed to be judging in the most marginal of cases, the idea that originalism, that the law has this objective reality that could be determined by some judge, is like totally crazy. Like that could be useful if you're like a city magistrate and you're just handing out wedding certificates, but it's like it's not like a way to run the country, right? Like it's not a way to decide if the ACA is going to stand or not. It's not a way to decide if there's a right to abortion.
Yeah.
So one article I want to point to about this is there's a judge on the Seventh Circuit. His name is Posner. Judge Posner wrote a really great article critiquing a book by Scalia about reading the law. And Posner himself is he's pretty conservative, and there's a lot to disagree with. And as he's gotten older, he's really announced that he's come to regret a lot of his conservative decisions. But he wrote a very good article for the New Republic, basically about how Scalia's originalist interpretations are totally bogus and useless.
Check out the show notes.
Posner is also an example of how a non-originalist can still be conservative. Posner is sort of big in the law and economics movement. So Posner's interpretive style, doesn't quite have the professed fidelity to the text that, say, a textualist would have. But what Posner does is that in resolving ambiguity, he tries to figure out, using an interdisciplinary analysis of law and economics, what is the thing that would be best for society? What is the thing that Congress probably intended? If Congress intended society to be well and there's ambiguity in the statute, what would an interdisciplinary approach tell you is the thing that ought to be? And, this is an interpretive style that still leads to tons of conservative opinions, but is itself not originalism.
I think part of the problem with the, with this discussion of originalism, textualism, and its flaws is that at the end of the day, it has appeal, right? Like it's appealing to tell a layman crowd, well, I'm a textualist. I just do what the Congress writes the law, and I just apply the law as it's written, right? I'm an originalist, right? Congress writes the law, and I try to apply, even if there is an ambiguity, I try to apply what Congress wants, right? The problem with that is that's true of all judges, right? Like that, wherever you fall on that spectrum, I don't think it, like you were saying, AJ, it's not as if Ginsburg just chucks the text of the statute out of a window before deciding an issue. They all start with the text of the statute. And I think for the vast majority of cases, right, you're at the district court level, and even, a significant portion of the intermediate appellate court, circuit court level, right? You really can resolve these cases by relying on the text of the statute, right? Because oftentimes you're not dealing with an ambiguity, but it's when you get to that, the margins of the law, that ambiguous area, that you really need to grapple with, okay, how do we figure out what this law means in context, right? Like in context of what the writers of the law are trying to do, in context of how that law applies in reality, and in context of the result in the case. If I apply the law one way or the other, am I going to cause some sort of injustice, or am I going to cause some sort of absurd result? It's all of these things that together come, all of these tools in your belt that you use to decide what does this law mean. So that's the problem, I guess, in this debate, is that it's super easy to say you're an originalist or you're a textualist, right? But what does it really mean, right? It's like saying, I'm for America. Well, yeah, everyone's for America, right?
Yeah, exactly, right? Alito finds a way to be completely deplorable without being an originalist. So, maybe this discussion is totally misplaced. Like, maybe there are much more important things to be talking about with Gorsuch. But this whole like balls and strikes thing, just like really is like deeply upsetting to me. I think it's a real abdication of being able to take responsibility for the decisions that you make in the lives that you influence as a judge.
I think my favorite quote on that is, Rucha, I think you once said, you didn't go to Harvard to be an umpire, right?
Yeah, exactly. And I think here's the part about original. I mean, so we've been like on originalism this entire time, and let me talk for a second about the part of originalism that's like maybe attractive to me, right? And so think of the Fourth Amendment, okay? And I think if you weren't an originalist, but you were a living constitutionalist, let's say, or whatever the proper term would be, you could very well look at the Fourth Amendment and say, you know, the founders did say what they said about unreasonable searches and seizures, but, you know, in this modern day and age with terrorism and all of these other terrible things, the definition of an unreasonable search, it's just we needed to evolve, right? We all need to give up our privacy completely because of just how scary the world is, you know? Or maybe you could say that about equal protection, right? Maybe you could say, well, you know, it's just a scary world. Maybe we can't have rights for everybody, you know? And those arguments kind of trouble me a little bit. And I think a reversion to originalism there it can be a helpful one.
I disagree.
But I don't even know if that's the issue, right? Like my criticism of those talking points is not that we need to abandon originalism or textualism, right? Like I think the text of a statute is where you should start when you're interpreting the meaning of the statute. That is not a radical position. That is not but neither is that a position that should be owned wholly by textualists or
I agree with that.
Originalists, right? Like, you know, that's where all judges, at least in my experience, start when they're interpreting a statute. They always start with the text of the statute, right? But you know, and sometimes, and in fact, a lot of times, the text of the statute answers the question for you. Right, you know, in your example, Ruchit, of the hypothetical judge who says, "Well, we're living in dangerous times, so maybe we shouldn't have these Fourth Amendment protections." Well, I would say to that, you know, they're obviously they're not being originalists, they're not being textualists, but I would also say that they're not actually doing a true statutory construction, a true analysis of a statute, right? Like they're not, you know, the canons of construction are there for a specific reason. They're supposed to be the tools that these judges use in determining the meaning of the statute, right? And you know, it's all in context, but like, when you have someone go that far afield, I think everyone can agree, well, that's one step too far, right? But again, all of these issues, you know, are sort of line drawing issues, if you will, right? And it goes back to like, why do we have judges? It's for their judgment, right? We want to hire judges that have good judgment and not hire judges that have bad judgment.
That's exactly my point, right? I mean, I'm not just upset at originalism because professing that there's this objective reality to the law removes from you the responsibility for judging. I think there's a step deeper that Tom is getting at, which is that judges are useful for judging. And when you're an originalist and it's very convenient for you that the outcome of the case is consistent with your conservative priors, and because of the objective reality of the law, there's no need to question your conservative priors, you're not really judging. That one of the things that a holistic analysis of the law does is it forces you to confront your prior dispositions in a way that is actually itself the act of judging, right? That is exercising judgment. And that if you are a person who doesn't believe that there's an objective reality to the law, that you have an ambiguous statute and you just need to find the thing to do that is the thing that should be done, you know, sort of like a Posner sort of analysis. You know, a reflective and good judge doesn't get to hide behind some sort of objective reality to the law. They actually have to confront the fact that they are the people who are deciding what the law is. And that amount of responsibility it should cause you to exercise actual judgment while you are judging.
Yeah, I agree with that.
Healthcare?
Can we get Stephen Breyer on the show?
Stephen Breyer is so good.
No, we need Souter. Souter
is also very good.
So Souter, I think we could definitely get.
Like, he is living out on a farm in New Hampshire. He's got nothing to do. I know he's got nothing to do. He can come and hang out with us for a couple of hours.
Dude, do you think Souter is listening to our podcast? And if not, can you send him an email suggesting that he do?
Yo, Souter, check out the show notes. Souter, hit me up on Twitter at AJSmall, heartlanded.com. Yo, Souter.
Oh.
All right, healthcare. Rich, you have a lot of healthcare in the show notes.
The Republican healthcare bill was up for vote, and then they took it down for vote.
So this makes a lot of my show notes here, which maybe we should post anyway, kind of pointless because I didn't realize they were going to vote before I wrote these show notes. So they really fucked us on that one, guys. Sorry, can we edit that out? The F word there. I want to keep this a PG show.
Bruce, maybe you should just stop cursing.
Yeah. Okay. So I want to start like way back. There is a Ezra Klien article at Vox from September of 2014. And this goes way, way back. But basically, there's been a bunch of literature about why it's useless to talk to each other about politics, that people believe their political convictions even more strongly after being confronted with evidence of them. And so talking to people about politics only entrenches their belief. There's a lot of reason why you shouldn't talk to each other about politics and we should stop having our podcast. But one piece of literature, and I don't particularly have the expertise to tell you if there's like a methodological problem with it, but Grossman and Hopkins in Policymaking and Red and Blue talk a lot about why Democrats and Republicans go about policymaking differently. And there's one passage I want to read.
This is interesting.
The data also explain why Democrats and Republicans have so much trouble understanding each other. Democrats tend to project their preference for policymaking onto the Republican Party and then respond with anger and confusion when Republicans don't seem interested in making a deal. Republicans tend to assume the Democratic Party is more ideological than it is, and so see various policy initiatives as part of an ideological effort to remake America along more socialistic lines. Basically, the premise here is that liberals, and liberals tend to vote Democratic, that liberals are very interested in policy outcomes. They're actually interested in achieving policy making, and in order to achieve policies, you have to have consensus, right? You need to have, 50% plus one votes. And so liberals, on the whole, tend to be very interested in compromise. The Republican Party and conservatives are much more ideological. They are much more they're much less focused on policy outcomes and much more focused on ideological outcomes. So there's an old joke about libertarianism. You would say to a libertarianism, what's wrong with, why is there all of this inequality in the country? And the libertarian says, inequality is very bad. And then you would say to libertarian, what should we do about it? And the libertarian says, the causes of inequality are very good. No one's laughing.
I don't understand.
But
I'm really confused.
But basically, that conservatives are much less concerned about the negative outcomes of ideological legislation, whereas Democrats are much more flexible ideologically, but are much more concerned in positive policy outcomes. And what you see is that Democrats and Republicans are completely unable to talk to each other. That Republicans, because they're ideological, assume Democrats are ideological. And so when Democrats want to pursue liberal policies, Republicans assume that it is coming from a place of ideological socialism. On the other hand, Democrats are much more policy-oriented. And so Republicans have these conservative ideologies. And it just so happens that those conservative ideologies increase inequality, decrease the services available to the poor, cause negative policy outcomes in the country. And from a Democratic perspective, it appears that Republicans are horrible monsters that hate the poor. But really, Republicans are much more ideologically interested in conversations about the size of government or the role in government in people's lives. And it just so happens that removing the government's roles in the delivery of healthcare in America would cause 20 million people to lose their health insurance, and tens of thousands of people would die due to a lack of access to care. And so Democrats see that Republicans want to pass these kinds of bills, and they say these Republicans are horrible monsters. Look at the horrible policies they want. And Republicans look at Democrats and say these Democrats are horrible monsters. They want to fundamentally reshape the American way of life. And so there's no point in Democrats and Republicans actually talking to each other because they'll never be able to understand each other.
So how does that fit in with, for example, during the entire Obama presidency, Republicans were screaming, our deficits are crazy. We need to get our deficit spending under control, blah, 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 blah. And since end of last year, beginning of this year, we haven't heard not much about deficits.
I think that individual people are extremely flexible in what issues they choose to care about based on the priorities of what's convenient for them. That a lot of people are imperfectly rational, basically. But you can't take individual people's lack of rationality as a way of saying that the abstractions that apply to larger groups of people sort of don't hold. So here's why I think that this is an important background. Harold Pollack, writing for Politico, had an article, Paul Ryan failed because his bill was a dumpster fire. Pollack wrote they didn't do any of this being sort of consensus building, workshopping, policy development. They didn't do any of this. Perhaps Republicans didn't do any of this because they believed they would never have to. Secure in the knowledge that they would face President Obama's veto, Republicans ran through a succession of extreme repeal and replace bills that resembled the AHCA's original draft. These bills excited the Republican base, but would have horrified most other Americans if they ever found sufficient reason to look. Then congressional Republicans suffered what George W. Bush might call a catastrophic success with Donald Trump's unexpected victory. They had nothing real to deliver. And I think the overall article is very good, but this passage from the article is very bad, right? That the original draft of the AHCA, the bill that failed this week, Paul Ryan's healthcare reform bill that failed this week, that started out, the first draft of the AHCA was the same bill that Republicans had been voting on for 6 years. And Paul Ryan had close to 200 members ready to vote for it again. So they actually had gone through the effort of consensus building inside their caucus. They had a huge majority of the caucus that were ready to vote for it. They had actually conducted an exercise of developing this bill over the course of 6 years. Here's the problem with the bill. The bill was extraordinarily ideological, and the process that Paul Ryan used to try to move the bill was completely devoid of reference to the policy outcomes that the bill would cause. They didn't want to see the Congressional Budget Office score of how much the bill would cost, or how many people would gain or lose access to healthcare because of the bill, right? The actual policy outcomes are totally a step aside from the ideological goals that Paul Ryan was trying to pursue. Paul Ryan was trying to pursue an ideological goal of minimizing the federal government's role in the delivery of health insurance. And Paul Ryan has an ideological goal of minimizing means-based assistance to Americans, because, I mean, there's a little bit of policymaking there, and that Paul Ryan seems to think that means-based entitlements discourage work because the poorer you are, the more help you get. And then if you become less poor, you get less help. And so you sort of decrease the benefits of earning more money. But I mean, deep down, that's like, that still has its basis in this like sort of ideological, Ayn Rand style objectivism that is opposed generally to welfare, to people who didn't go out and John Galt their way to success. The point I'm getting at is that this is a caucus that had a bill that was full of the ideological commitments that they've been professing for 6 years, and they came up, say, 20, 30, 40, 50 votes short. And but what that says to me is that 80% of the Republican caucus cares about ideology, and 20% of the Republican caucus actually spends any time thinking about the policy.
Can I ask, if they had passed this bill, or version of this bill, multiple times in the past when Obama was president, why were they not able to get the votes this time? Is it because when they passed it previously, they knew that there is no way Obama would sign it or he would veto it? And therefore they were just voting as a show?
Two reasons. One, I think that it didn't really matter because it was not going to get past Obama's veto. But second is that the people in the country and the media didn't pay attention to it because it wasn't going to get past Obama's veto. So previous times when this bill had been voted through, it had been voted through as just, this is the 56th time the GOP House has voted to repeal the ACA.
Yeah.
And now we're in a situation where it could conceivably become law. And so the CBO has had to score it, and people have had to actually confront what the results of the bill would be. And suddenly the bill is polling underwater, 56% poll respondents opposed, 17% for. And, there's still some corner of the GOP that is concerned about voting for a bill with only 17% of the country in favor of it.
AJ, I was going to say, I just don't. Yeah. I was going to say, I guess I don't think they ever passed this type of a bill before, because if I recall, what they wanted to do was not to give people tax credits, but basically move everybody into either high risk pools if they were high risk, or to get everyone to start using HSAs. You know what I mean? So I think this bill was just like a monumentally bad bill that like even the conservatives couldn't really get on board with, because I guess I disagree with what you said about how this bill contained elements or actually helped move to achieve the policy goals that they wanted to achieve, which was a less limited role for government, or a more limited role for government in the healthcare industry. I just don't think this bill did that. It was basically Obamacare light. Instead of having a mandate, they had a 30% penalty. Instead of having lots of subsidies, they had slightly less in the way of subsidies. It just didn't do any of the things. I mean, the conservative caucus, the Freedom Caucus talked about this a lot, obviously, but it just didn't do much to reduce government's role in healthcare. And I think it couldn't, frankly, because of the process that they needed to use for budget reconciliation. So they couldn't really do a lot of regulatory stuff in this bill, which is what they wanted to do.
So here's an article from the Heritage Foundation from February 2017. The title is, "In Repealing Obamacare, Congress Should Look to the 2015 Reconciliation Bill." So here's what it said. The last time Congress tried to use reconciliation to repeal Obamacare in 2015, the House and Senate took very different approaches. The House initially passed a much more limited repeal that left the bulk of the of Obamacare in place. Then the Senate amended that bill to include the repeal of Obamacare's core parts, funding for Medicaid expansion, exchange subsidies, and nearly all of the law's tax increases. Ultimately, it was the Senate's more robust repeal bill that was adopted by both chambers and sent to their president, who eventually vetoed it. The Senate's amendment to the bill included rescinded funds for Obamacare's Prevention and Public Health Fund, increased funding for community health centers, eliminated funding for territories to set up exchanges, blah, blah, blah. Repealed individual and employer mandates by limiting the penalty for noncompliance, prohibited abortion providers from receiving certain federal reimbursements, repealed the ACA's enhanced federal funding for the Medicaid expansion, repealed – right, like this Senate version is much more similar to the AHCA. I don't think that Paul Ryan drafted this bill in a vacuum. They didn't vote 55, 60 times to repeal the ACA and then start writing the actual repeal bill 3 months ago.
I think that's what they did. I think because of the limited means that they had. So I guess it's not surprising that they used the 2015 budget reconciliation bill, but I don't think this this had some of their wish list, but definitely not enough of it. You know what I mean? I think there's a reason they voted this down so dramatically, is it just wasn't a particularly conservative bill, other than like the sort of, kill Planned Parenthood funding and things like that. It just didn't have a lot of market reforms in it.
Well, and the $300 billion tax cut for the 1%.
What was the tax cut?
The AHCA would have repealed $300 billion of tax increases on high income individuals that were used to fund the ACA so that it can be passed in reconciliation.
Oh, are you talking about the millionaire's tax?
It would have repealed a whole bunch of taxes. So the ACA, Obamacare, was passed in reconciliation. One of the rules for reconciliations is that bills have to balance over 10 years. So the ACA was funded in part by fairly modest cuts to Medicare that are sort of those Medicare cuts were mostly offset by structural reforms to the healthcare market so that people who are on Medicare wouldn't actually experience decreases in their care. So there were some cuts to Medicare that was basically money freed up by the structural reforms of the ACA, but there was also about a 3% increase in the effective tax rate on high income individuals. And that 3% increase in the effective tax rate would have been repealed by Paul Ryan, and that would have decreased taxes by about $300 billion. It was a $300 billion tax cut for the 1%. That was part of the AHCA. The reason why the AHCA was so much less generous, gave so much worse benefits to people in assisting them on obtaining health care, is that the $300 billion of taxes that would have gone to fund better access to health care were being repealed. So in order to get through on reconciliation, the bill itself had to be much less generous.
I thought they just wanted less generous benefits in general. I didn't realize it was to fund a tax cut. It makes more sense now.
Isn't that also the reason why they couldn't get the across state lines business in this bill?
I think that had to do with the budget reconciliation issue, which is that would have been a regulatory thing, not a fiscal thing. See, I think that was a big – and they also didn't have anything about tort reform in there. So I guess that's what I meant when I said like they have a bunch of like the Republicans have historically had a bunch of goodies that they wanted in a healthcare bill, including selling across state lines and, nationwide, med mal reform, then, HSAs that go to like $20,000. I mean, things like that. That just had no presence in this bill.
Well, I'm sure version 2 will be much worse.
Yeah, I don't know if there's going to be a version 2. I think I get the feeling that,
why do you think there's not going to be a version 2?
I think they want to get on with tax reform. Maybe it'll be a couple years from now, but I think they learned that either people don't feel as strongly about hating Obamacare as they thought, or maybe people actually kind of like it. You know what I mean?
They ran for 8 years on repeal and replace. You don't think they're going to at least try 2 times?
I don't think so. Maybe like in a couple of years, maybe after the midterms. I don't think they're going to try between now and the midterms.
What about just a flat-out repeal of Obamacare? Do you think that they'll do that?
I don't think so, because the Senate seems to think, and many of the moderate House members as well, seem to think that you need to have something to replace it with, and that can't just be go back to the old way. I think this goes to sort of something that Scalia said sort of inartfully, which is it's, once there's an entitlement, it's very hard to take away. Now, he was referring to the right to vote, so that was not cool, but I think he was actually he was right in that sense too, wasn't he? It's very hard to take away somebody's right to vote, even though it's not an entitlement. But you just can't take this stuff away. I think it's they just gave up so easily, though. It almost makes me think that maybe I'm wrong, and maybe they've got something sneaky up their sleeves.
Yeah, I think you're wrong. I think the almost probability is that they're going to try again.
I don't think so. I really don't think Donald Trump actually cares about it, and Paul Ryan is so incompetent.
Yeah, I don't think he gives a
Paul Ryan is such a huge fraud of an intellectual. Paul Ryan...
AJ's never been happier. For our audience, AJ has been...
But, okay, I've hated Paul Ryan since at least like late 2011, 2012, I guess. Especially when he was the VP candidate. But basically, the same way that Trump cons people, the same way that Trump cons everyday people, the way Paul Ryan cons these sort of self-idealized Washington centrists. Paul Ryan has never passed major legislation. He's never built a consensus around a major legislation. He is an objectivist ideologue who spent a lot of his early adulthood reading Ayn Rand and then running around Washington, D.C. trying to get other people to read it. And he says that his only breaking point with objectivism, the reason why he doesn't consider himself an objectivist today, he says, is because Ayn Rand was pro-choice. Right, like he's too conservative for Ayn Rand, is Paul Ryan's point. He's This isn't a person who is serious about policymaking or moving legislation or leading a caucus or leading one of the houses of Congress. This is a person who just wants to repeal as much of the law as he can as quickly as he can do it without any reference to the kind of deal making and consensus building it takes to pass legislation.
Well, I think he just doesn't know how to do it, right? I don't think he's not interested. I think you're right in that he just does not know how to actually like take a bill and turn it into a law, you know? And I think he proved that he doesn't have what it takes to be Speaker of the House. You know, you have to like be able to threaten people, and you have to be able to get them to vote for your priorities and for the president's priorities. And I mean, I think this goes back to the fact that Donald Trump is a horrible judge of talent.
All right. Everything we know about the Supreme Court?
Sure, if we're done with Paul Ryan and the American Healthcare Act.
I'm done, dude. I'm done. America's done. I don't know. There's so much more. Okay, actually, one last thing about this. Did you see Donald Trump tweeted out, everybody watch Judge Jeanine on Fox News?
Yeah.
And then Judge Jeanine comes on, and the first 6 minutes of her show is about how Paul Ryan needs to step down as Speaker. And now Donald Trump is saying, oh, like this wasn't a message that Paul Ryan needs to step down as Speaker. You know, I think Trump's plan here is, I think Bannon, there have been a lot of articles saying that Bannon hates Paul Ryan and Breitbart hates Paul Ryan. Yep. And I think sort of the idea is to undermine Paul Ryan to the maximum extent possible in the case of any legislative failures from now on.
Yeah, I think also so Trump is throwing the House Freedom Caucus under the bus and has been throwing Paul Ryan under the bus, although more indirectly. And I mean, I've read that like Trump loves pitting people against each other and seeing, you know, who the stronger person is and watching that person emerge. Apparently he's been running the White House that way as well, to like make people as, nervous and anxious about things as humanly possible. But I think he's basically trying to weaken both of them. And if one or both of them go down, it's like more power for him. So he doesn't really care.
So we're living in the Hunger Games?
I think the Republican Party is. I think the rest of us are fine.
Yeah, we'll see about that.
All right. Everything we know about the Supreme Court?
Everything we know about the Supreme Court. Okay, I got 3 cases for y'all today. The first is a patent case. It is Impressions Product Incorporated versus Lexmark International Incorporated. It comes out of the Federal Circuit, and basically here are the facts. Lexmark sells printer cartridges. A microchip in those cartridges disables them after their first use, so purchasers agree when they buy the cartridges that they'll not reuse them or refill them except by returning them to Lexmark. Impression Products is a company that operates a business that recycles these printer cartridges, and they do so. They recycle Lexmark printer cartridges in violation of the restriction. The question before the court is whether Lexmark's patents follow the cartridges through their sale, use, and resale into the hands of Impressions Product. And it comes from this doctrine called the Patent Exhaustion Doctrine, also known as the First Sale Doctrine, which holds that the initial authorized sale of a patented item terminates all patent rights to that item. Right? In other words, when a firm holding a patent sells the product to which the patent applies, does the sale necessarily exhausts its right to enforce the patent as to that product, right? So we're talking about as to the specific product.
So Tom, just to be clear, what you're saying is the exhaustion doctrine says once Lexmark sells me a printer, they cannot then accuse me of patent infringement as it relates to however I decide to use that specific printer. Not that I can't – obviously, if I create another printer, that's a different story.
Yeah. Well, yeah, exactly. So like to put it in a more concrete example, let's say you invent the light bulb, right? And you patent the light bulb and you start producing light bulbs, right? Yeah, and then you sell a light bulb to AJ, right? One of the light bulbs that you've produced under your patent, right? And AJ goes and installs that light bulb in his home. You can't then show up with your thugs and tell AJ, hey, AJ, I've got a patent on that light bulb. You're using that in violation of my patent, right? That's the idea.
Gotcha.
That's this patent exhaustion doctrine.
How did Lexmark win in the court below?
How did they win in the court below?
Yeah, like what is the court below doing ruling for Lexmark?
I think that's how courts are, yo. So this is out of the Federal Circuit, and you should actually see this opinion, right? Like it's the first 10 pages are the lawyers working on it, and then finally the opinion starts. But yeah, to answer or to put a pin on it, Lexmark did win at the court below, and so the question, there's really two sort of questions here, because what Lexmark was doing was what's called a conditional sale, which transfers the title of the patented item while specifying post-sale restrictions on the article's use and resale of the patented item, right? And so, I mean, it seems to me this conditional sale concept is just a nice way to get around the patent exhaustion doctrine, right? And I think reading up on this case, both sides agree that at some point in the chain, the patent exhaustion doctrine applies. The question is, where in that chain of selling one, Ruchit selling his light bulb to AJ selling his light bulb to me, where does that patent exhaustion doctrine apply? Like, is it can you craft a rule that, maybe that's what Lexmark would want, at least for the first person that you sell the light bulb to, you have the right to tell them how they can use the light bulb or what they can do with the light bulb. But maybe for the second person, you don't have that right. You know what I mean?
Yeah, no, I know exactly what you mean. I think this is going to be a very important case for it's actually, I mean, somebody could argue, I guess, that all patent law is anti-innovation, but I think this particular idea, if Lexmark is to win, would be particularly anti-innovation because it would allow companies to basically lock you in even further into their product ecosystem, right? You could see...
Yeah, exactly. So that's the argument against Lexmark, right?
Yep.
The other issue is that it gets more complicated with software patents, right? Like software patents do this sort of thing all the time where, when they license you a software, they tell you exactly how you can and cannot use it, right? So that's one of the issues that the court is grappling with here. The other issue that the court is grappling with is what if the sale is inside the United States versus outside the United States? There's this case called Kitstrang v. John Wiley and Sons, which held that a copyrighted work lawfully made abroad is subject to the same post-sale restrictions as work made domestically. So, I mean, the idea is that, you're going to get sort of the same protections under U.S. law as you for something that's made, outside the United States.
All right, I'm ready to enter my judgment.
Okay, AJ's got a vote.
Yeah, me too.
Unanimous for impressions.
Okay, so that is a 8-0 reversal?
Yeah.
Okay. Ruchit?
Well, let me first disclose that I did about 20 hours of billable work for Lexmark at one point in time. They were once my client.
Oh. So we have a paid shill for Lexmark?
We do. A formerly paid shill, no longer paid shill.
But you're a paid shill, you're always a paid shill.
They don't own me forever, dude, just for those 20 hours. I will say that it's going to be 6-2 for impressions. And the reason that I will say that is I think the Supreme Court has been trying to roll back the expanse of patent law for some time. And I think that will continue. I think the two dissents, I think you'll see a Breyer will be one of the dissenters, and then so will Alito.
Okay, well, I'm with AJ 8-0 reverse for impressions. I think, so my thought is, courts like to do this thing where if patent law doesn't provide a remedy, if there are other things that do provide a remedy for the harms that Lexmark claims will occur, then they'll rest on that. So in this sense, like, you know, you can imagine Lexmark would, you know, contractually tell Impressions in the future, if I'm going to sell you this product, you can no longer, you know, instead of a patent infringement case, what Lexmark would have is maybe a breach of contract. And of course, Lexmark doesn't want that, because I'm sure there are more penalties and money that you can get in a patent infringement case than in a breach of contract case. But I think that might be one way for the court to answer this question.
Although, Tom, I think in this situation, the problem is precisely that Lexmark sells a printer to you, and then you go and get the cartridges refilled by somebody like Impressions. And so there is no contractual relationship between Lexmark and Impressions. So if Lexmark can't sue Impressions for patent infringement,
maybe
they're
that's
really
why.
Just screwed. Yeah. They have to do this.
That's a good point.
Otherwise, Impressions and people like them will continue providing cheap ink to Americans everywhere. And what will come of the world then?
Yeah. I don't know. Okay, so I think we're all on the reversal side, and Ruchit has the 6-2, and AJ and I are 8-0, right?
All right.
Yep.
What's the next one?
Next case, County of Los Angeles v. Mendez. So this is a case in which L.A. County was searching for what I'm going to use in scare quotes, a parolee at large. I don't know exactly what that is, but presumably someone who went on parole and then decided not to report in. So apparently this parolee at large had been seen bicycling around the front of a suspected drug trafficking house. And I'll also put that in quotes because, police like to label a lot of things drug trafficking houses. But so without a warrant for search or arrest, LA County officers went into the house using threat of force. So 2 officers went into the backyard to clear the yard. The 2 officers came across a shack, which that the district court made a finding that the officers could not have reasonably believed anyone occupied it. But apparently there were people living in there. The Mendezes were sleeping on a futon in that shack. Mr. Mendez apparently kept a BB gun next to his bed. And with their guns drawn, the police officers pulled open the door of the shack. And when he heard the officers enter, Mr. Mendez woke up and moved his gun out of the way. There's some contrary testimony as to whether the gun was ever pointed at the officer or not.
Their guns were drawn, but they didn't reasonably suspect that the dwelling was occupied?
Well, that's what the court found, that looking at the shack, the district court found that the officers could not have reasonably believed that the shack was occupied.
But their guns were drawn.
But their guns were drawn when they went in. All right?
Doesn't make any sense, Tom.
Well, cases sometimes have their wrinkles. But yeah, their guns were drawn, and they opened the door, and when they opened the door, one of the officers shouts guns, and the 2 officers fires 15 bullets into Mr. Mendez. Mr. Mendez says, while bleeding out on the floor, "I didn't know it was you guys. It was a BB gun." Okay? Mendez and his family sue under Fourth Amendment violations, claiming, hey, you entered without a warrant, you entered without knock and announce, and you used excessive force. The district court found for Mendez, but awarded only $1 in damages, saying it's a violation because there was a violation for the failure to knock and announce and the warrantless entry, but the court thought that the officers were being reasonable the moment that force was used. So when they pulled the trigger, the court thought, well, they were being reasonable because they thought this guy had a BB gun that was a real gun. Okay? But the officers were unreasonable in entering the abode to begin with and not knocking and announcing that they were police officers. All right? Ninth Circuit affirms, and what the Ninth Circuit is says, look, the entering the shack without a warrant is a violation of an clearly established rule. The failure to knock and announce was not a violation of a clearly established rule, and neither was the shooting. It was an excessive force, right? But the Ninth Circuit has this thing called the provocation rule, which basically says, look, if an unreasonable act of an officer provokes an act that would otherwise be reasonable, so in this scenario, an unreasonably entering a shack without a warrant, results in what is a reasonable occurrence, that is, the officer shooting what he thought was an armed individual, right? Then you can still recover from the officer under for the constitutional violations. And so the issue before the Supreme Court is, is the Ninth Circuit's provocation rule good or bad? If it's a good rule, then do you also have to prove a causal link between the damages and the provoked incident, right? So do you have to prove a causal link between whether between the shooting and going into the shack without a warrant, for example, and can there be superseding or intervening causes that breaks the chain of causation, right? The entire idea is there recovery for this individual for the shooting?
Rich, where are you at?
I'm here, dude. I have no idea what's going to happen here. I really do have no idea what's going to happen here. I feel more confused than Paul Ryan after the healthcare vote.
Yeah. Well, this is an example of how these cases can become really complicated, right? And it's not just a pure sort of, well, I'm a textualist, so I'm going to go find one way, or I'm an originalist, so I'm going to go find another way, right? Like it's, the issue in this case is clearly, look, the officers did some bad things, right? Like they entered this house without a warrant. They, didn't announce themselves, that sort of thing. But in the moment when they were doing, the thing that it ultimately injured Mendez, right, the shooting, they were being reasonable according to the court.
Do any other circuits follow the provocation rule?
No, I don't think so. I don't think they do follow the provocation rule.
Do any other circuits do anything similar?
No, there's this, it's called this Graham-Connor analysis, or the Graham v. Connor analysis. And so the actual question presented before the Supreme Court is whether the U.S. Court of Appeals for the Ninth Circuit's provocation rule should be barred as it conflicts with the Graham v. Connor regarding the manner in which a claim for excessive force against a police officer should be determined in an action brought under 1983. Right? So there's this Graham v. Connor test that looking into that, it seems more of almost like a totality of the circumstances test. So the Graham v. Connor says that the Fourth Amendment excessive force claim should be applied objectively and evaluated at the moment of the application of the force, right? So whether this provocation rule should win or this Graham v. Connor test should win.
I'm going to just take a wild guess and say that the Supreme Court is going to tell Mr. Mendez that he has lost.
Reversal?
I think they're going to reverse the Ninth Circuit. I think it'll be like 5-3 or something.
Yeah, so here's the thing, right? So you have this dynamic between so for the sake of the listeners, the Supreme Court only takes about 80 cases a year. So the vast majority of the law, the vast majority of appellate decisions are circuit court decisions that are not reviewed by the Supreme Court. And so individual circuits will develop their own view of the law, right? So you actually can have the state of the law be different in, say, the Fifth and the Ninth Circuits, for example.
So like Texas and California.
Yeah, so like Texas and California can have different laws. Like the Fair Labor Standards Act can mean different things in Texas and California. And when that happens, it's called a circuit split. And one of the things the Supreme Court does is it hopes to resolve circuit splits because there should be uniformity in the application of federal laws throughout the country. So, this is like a pretty egregious circuit split, right? I mean, I don't know very much about the provocation rule, but it sounds like it's sort of well developed through a line of Ninth Circuit cases, and then there's no other circuit that does anything remotely like it. And so I sort of feel like, I don't know. I don't think the Supreme Court is going to make the provocation rule apply nationally in all of the circuits. And so the only other way to do it would be to reverse.
Yeah.
Yeah, I think that's where we're going. Reversal.
So what's the vote count?
Oh, this is tough. I think it's going to be close to unanimous. I can't think of anyone who would dissent. Ginsburg?
Okay. 8-0 reversal?
If I wasn't going to go with a 5-3 reversal, I would go with an 8-0 reversal.
Yeah, that's the thing, right?
Well, which one is it? Is it 8-0 or 5-3?
I'm going to vote 5-3.
All right, I'll do 8-0 so that Richard and I can be different.
I'm going to go 8-0 reversal. We only have one more case, and this isn't actually a simpler case, I guess. This is Howell v. Howell. Comes out of Arizona.
Oh, I'm with Howell.
Yeah, you should be with Howell. Basically, there's this law called the Uniformed Services Former Spouses Protection Act, which allows states to divide up military retirement in a retirement pay in a divorce setting. So you and your spouse divorce, you have military retirement, say $1,000 a month for the rest of your life. The court, under the state court, relying on authority from the Uniformed Services Former Spouses Protection Act, can then order that retirement pay be divided up amongst the spouses. The only or the exception that applies in this case is that you can only divide up what's called disposable retired pay, which is the portion of your retirement pay minus any pay that is what's called waived in favor of disability benefits. So some background. When a veteran gets some form of disability from the U.S. government, it's usually, well, in the circumstances where it's tied to some form of active duty service, they get that money as a percentage, right? Like, let's say you're 40% disabled. That determines how much money you get as a disability benefit. But you can opt to waive some of the money that you get as retirement. You can waive some of that money, that saying you won't get that, but you will get it as additional disability benefits, right? And the reason that folks do this is disability benefits are not taxable, whereas retirement pay is taxable, right?
Nice, yeah.
So the Howells in 1991 did exactly this. In 1991, they had a divorce, and the court divided up the retirement pay in half. In 2005, Mr. Howell gets some disability findings, and he opts to waive a part of his retirement benefits in favor of getting them as disability benefits and therefore tax-free. But the decision to do that reduces the amount that Ms. Howell receives by $125 per month. Okay? So John, Mr. Howell, says, look, the Uniformed Services Former Spouses Protection Act doesn't say anything about when the retirement pay is waived, right? It can be waived at any time. He's using what some might call a textualist argument. He's saying,
good job, Mr. Howell.
Yeah, you can waive. It doesn't say you can. The law doesn't say the courts can divide up the military pay except for any portion that has already been waived. Right? Or there's no like time limitations is his argument. Right. And Sandra, Mrs. Howell's argument is that, look, the state courts don't divide up Mr. Howell's disability pay or require Mr. Howell to pay Ms. Howell from it. It simply orders that Mr. Howell give Ms. Howell half of his retirement pay. Right. And it ordered it at a specific time. So the originalist interpreting the court order would say, well, look, when the court ordered it, they ordered Ms. Howell would get $125 more per month than she's actually getting now. So she should get that extra $125. That's pretty much it. Basically the Supreme Court has to decide whether this exception to the Uniformed Services Former Spouses Protection Act applies, in a situation like this, where after the court has ordered the divvying up of these retirement benefits, a factual scenario changes and basically shifts some of those retirement benefits as disability pay. So what do you think? And just as one additional element of backup, the Arizona Supreme Court found in favor of Mrs. Howell.
Tom, there's been some discussion that Judge Gorsuch is too much of a corporatist judge. There's just no corporate outcome here. What will he do?
I don't know. Tom, you go first.
Well, I'm going to say 5-3 affirm. Affirm the Arizona Supreme Court. And you know, I don't have too much of a basis for saying that, other than I think that's probably the right result, right? Like the idea that you shouldn't be allowed to skirt your obligations to pay, right? By basically like a shell game, right? Like if you move some of the money that you have after the fact to disability benefits, you shouldn't use that act to undermine the court order that was initially in place. But, you know, I think this will be actually a pretty close case.
Tom, I am a humble scrivener, and I think that the Mr. Howell is going to win. I think it's going to be a reversal.
Yeah, what's the vote count?
5-3.
Yeah, I think it's 5-3, Mr. Howell.
It could also be 5-3 with. It could be 6-2.
I mean, it could be anything, Rich.
Yeah. No, that's not true. It can't be 10-0.
It could be.
Absolutely cannot.
It could be.
I mean,
they need to. I mean, Congress would have to pass a statute adding a 10th seat to the court. But the court's had 10 seats in the past.
I actually don't think Congress has to do anything. I think they need to confirm 2 judges, but other than that, I don't think.
No, they need to do legislation.
Is there actually a statute?
Yeah, there's a statute.
Yeah.
Oh, I didn't know that. I thought it was just historical norm.
So wait. So Tom is Mrs. Howell, and Richard and I are Mr. Howell.
Yeah. So and from here on out, I think we need to start using reverse and affirm, just because I think it'd just be easier to keep track of. And
okay. So I'm
uniform.
reverse.
So AJ 5-3 reverse in favor of Mr. Howell.
I'm actually saying 6-2 reverse.
6-2 reverse in favor of Mr. Howell.
But keep in mind, Richard also said it could be anything.
Yeah.
I am not willing to say it will be 10-0.
I'm 5-3 affirm.
Sidebar?
Sidebar. Who wants to go first?
I don't know. Do you want me to go?
Sure, if you want.
Okay. I'm only about a third of the way into this book, but I wanted to recommend it. It's by Mark Fisher, and it's called Capitalist Realism, Is There Any Other Option? The premise of the book is basically an explanation of capitalist realism, which is sort of this philosophy that capitalism has taken on this reality extrinsic to its objective reality, that there's this subjective reality of capitalism that it describes the way that we experience the economic system in which we live, that there's this view that there are no alternatives to capitalism, but also there are these ways that capitalist society entrenches sort of the capitalist view of the world. And one of the ways that it does that, and I found this super interesting, is that capitalism has developed a mechanism of performing anti-capitalist works of art inside capitalism. So you can think of things, one of the examples Mark Fisher uses is WALL-E, the Pixar movie, right? And so WALL-E is this like on its surface, this sort of sincere critique of the consumerist culture in America, and it depicts this sort of dystopian future society that's sort of, you know, half cartoon, half Brave New World. People go to the movies and they buy their popcorn and they sort of pay money within the confines of what we consider a capitalist system. They pay money to experience this anti-capitalist work, and it provides them this external source of absolution so that they can continue participating in a capitalist society and all of the depravity that entails, the sort of ways that capitalist realism is used to promote capital over the interests of the working class and things like that. Anyway, I don't think that you read this and immediately become a socialist. And as I'm getting deeper in the book, it mostly seems that Mark Fisher is complaining about how awful it is to be a higher education teacher in Britain. So it's most of everything after chapter 3 is just him complaining about how much he hates his job. But the first couple chapters, I think, are an interesting way of making you think about the way that dominant ideologies in our culture entrench themselves using self-reinforcing mechanisms, like the ways that capitalism has co-opted and allowed anti-capitalist works to be performed within its own structure. There's one passage about the subjective reality of capitalism that we experience that I thought was really sort of insightful. Here's what Mark Fisher says. Accordingly, neoliberalism has sought to eliminate the very category of value in the ethical sense. Over the past 30 years, capitalist realism has successfully installed a business ontology in which it is simply obvious that everything in society, including healthcare and education, should be run as a business.
And government.
Right? I mean, think about the neoliberal rhetoric of the last, basically starting from, even before Reagan, right? Where I'm a CEO president and I run the government as a business. The government needs to balance its budget or whatever, right? Everything is viewed through the lens of a capital labor relationship, as opposed to thinking of government as this unique institution with its own unique ways of acquiring debt, et cetera, et cetera.
I can go next if you guys want. I ran across this article published by a few folks working at Google titled Detecting Cancer Metastases on a Gigapixel Pathology Images. And so one of the things that artificial learning networks have been doing is they've been using photos of pathological specimens, right? So some in this article's example, whether cancer, basically potentially cancerous tissue cells, right? And determining whether they are or are not cancer. And so this article just says, look, we have the best breakthrough of any sort of machine learning system so far. And so they were able to detect 92.4% of the cancerous lesions relative to basically 80%, which was the previous best automated approach, and with human pathologists having a 73% sensitivity. Right. So I just thought this article was interesting because this is just another example of using, and really where the learning networks are really good at using these neural networks to detect cancer, and various other malicious lesions, right? They've used this in the dermatology context as well. To try to identify these things for doctors. And I don't know, it's made a lot of success. It's good. Science is marching forward, guys. We should be happy.
That is very good. So is compassion, Tom. Compassion is marching forward too, and that's what my sidebar is about.
Yeah? What is it?
Just as science marches forward, so does compassion, and that's my sidebar. So the New York Times has been doing this great series over the last several months, or in fact it may have even been a year at this point, about Canadians adopting refugee families. So Canada has this unique program, which other countries are actually thinking of starting at this point, but where they allow private sponsors to adopt refugees. So basically you come up with $25,000, or I think it's $23,000, and Canada will let you adopt a refugee family. And they will come here and you're kind of their sponsor. So there's a monetary commitment, there's a time commitment, and there's obviously an application process. But something like 25,000 families have been resettled this way into Canada. So this article, which you'll see in the show notes, the title is Canadians Adopted Refugee Families for a Year. Then came month 13. And the idea here is that the Canadians made this commitment for a year. And then, so they just kind of review what happened during that year. And then everybody's emotions and thoughts and fears and hopes and dreams when the refugees were kind of on their own without a sponsor. So it's a really, really heartwarming article. And anyone that has been doubting humanity should read that, because there were tens of thousands of Canadians that said, listen, we're going to put up our money and our time to help people and help them become Canadians. It's really cool.
Everybody listen to the show notes. Go to the show notes, click on the Canada article. Click on Canada. Click on the Canada, learn about humanity.
AJ, when you move to Canada, is this how you're going to get in?
No, I'm just going to use my Canadian passport to get in.
But don't you have a family in Canada that can readopt you?
I don't need to be
your family.
I have family there. There's no I wasn't adopted. There's no readoption. There's no adoption or readoption. I used to live there and now I live here. And when the death squads are in the streets, painting yellow stars on the shop windows, I'll probably move back to Canada, and I'll use my Canadian passport to get there. I don't need to be adopted or readopted.
If any of the folks that help these refugees in this New York Times article are listening, please, AJ needs your help too.
No, I don't need help. This is the... No. God, please don't send me your help. Do follow me on Twitter at AJ Small.
And do tell your friends, whether they be refugees or fellow Canadians with compassion that adopted refugees, to listen to our show and to go to heartlanded.com.
Heartlanded.com. Check the show notes.
But seriously, if you're one of these people,
article looks super dope, and I'm super supportive of treating refugees well.
I'd also want to say that if you are a Canadian, whether that is someone that came as a refugee or that, is featured in any of these articles, I would love to talk to you because I think what you did was awesome.
Yeah. Should we call it?
I'll call it.
What do you call it?
A podcast.
Tom's dying. Tom, are you going to feel better?
Tom, are you okay, dude?
I've actually been sick all week long. I'm taking depots and basically hacking out a lung.
Dude, what's going on?
No, I've just been traveling a lot. That's all.
All right, guys. Good show. Should I hit stop? I should probably hit stop at this point.
Hit stop. I'm going to hit stop.
We can all hit stop.